Definitions of aggression requires international legal responsibility for the established facts of aggression. The aggression of the Russian armed forces against the people of the Chechen Republic is a fact established and confirmed by thousands of witnesses who are ready to confirm specific facts at any international court of justice. The same applies to crimes against humanity, massive violations of international humanitarian law by generals, officers and soldiers of the Russian army. Representatives of the Chechen resistance who have committed grave crimes against the population of the Chechen Republic must also appear before justice. Fifth conclusion. The war in Chechnya has all the signs of an international conflict, and, accordingly, it requires international intervention in this conflict in more energetic forms than has happened in previous periods, as well as at the present time, which is characterized by a high degree of passivity of international organizations and individual Western powers. And this, in turn, is perceived by the Russian ruling circles as open encouragement of her predatory war in Chechnya. Sixth conclusion. The Zakayev case directly raises the question of the status of the Chechen Republic as a state before the British legal system. Seventh conclusion. Any actions or inaction of Mr. A. Zakayev, as a plenipotentiary representative of the legitimate authorities of the Chechen Republic, elected with the active assistance and supervision of international organizations, OSCE, should be considered as fulfilling his functional duties, including the duty to protect the interests of his country. First Chairman the Russian Parliament Professor Khasbulatov R.I. Chechen Press, 16.06.03. Appendix to the legal analysis of R. Khasbulatov, and the procedure for resolving issues related to the exit of the Union Republic from the USSR. Law Supreme Council of the USSR April 3, 1990 N 1409 I, VVSS 90-15, Article 1. The procedure for resolving issues related to the secession of a Union Republic from the USSR in accordance with Article 72 of the Constitution of the USSR is determined by this law. Article 2. The decision on the secession of a Union Republic from the USSR is made by the free expression of the will of the peoples of the Union Republic through referendum, popular vote. The decision to hold a referendum is taken by the Supreme Soviet of a Union Republic on its own initiative or at a request signed by 1/10 of the citizens of the USSR permanently residing in the Republic and entitled to vote in accordance with the legislation of the Union of the USSR. A referendum shall be conducted in the manner determined by the law of the USSR, the law of a Union, autonomous republic on a referendum, if their provisions do not contradict this law. The referendum is held by secret ballot no earlier than 6 and no later than 9 months after the decision to raise the question of the withdrawal of the Union Republic from the USSR is made. Citizens of the USSR who permanently reside on the territory of the Republic at the time the question of its secession from the USSR is raised and have the right to vote in accordance with the legislation of the USSR take part in the referendum. Republics from the USSR. Citizens of the USSR who permanently reside on the territory of the Republic at the time the question of its secession from the USSR is raised and have the right to vote in accordance with the legislation of the USSR take part in the referendum. During the voting, any kind of campaigning on the issue submitted to the referendum is not allowed. Article 3. In a Union Republic, which has autonomous republics, autonomous regions and autonomous okrugs, a referendum is held separately for each autonomy. The peoples of the autonomous republics and autonomous formations retain the right to independently decide on the issue of staying in the USSR or in the seceding Union Republic, as well as to raise the issue of their state legal status. In a Union Republic, on whose territory there are places of compact residence of ethnic groups that make up the majority of the population of a given area, when determining the results of a referendum, the results of voting in these areas are taken into account separately. Article 4. To organize a referendum on secession from the USSR, to determine the date of the referendum and to summarize its results, the Supreme Soviet of a Union Republic shall form a commission with the participation of representatives of all interested parties, including those mentioned in Parts 1 and 2 of Article 3 of this law. Article 5. To ensure complete freedom of expression of the will of the peoples of the Union Republic in the preparation, conduct and determination of the results of the referendum on secession from the USSR, the Supreme Soviet of the USSR, in agreement with the Supreme Soviet of the Union Republic, decides on the presence on its territory as observers of authorized representatives of the USSR, Union and Autonomous Republics, autonomous entities. The Supreme Soviet of the USSR may, if it deems it necessary, invite representatives of the United Nations to the territory of the Republic during the voting. Article 6. A decision on the secession of a Union Republic from the USSR is considered adopted by means of a referendum if at least two-thirds of the citizens of the USSR permanently residing in the Republic at the time the question of its secession from the USSR is raised and have the right to vote in accordance with the legislation of the USSR. The results of the referendum are considered by the Supreme Soviet of the Union Republic. In a Union Republic, which includes autonomous republics, autonomous regions, autonomous okrugs or places of compact residence of national groups referred to in Part 2 of Article 3 of this law, the results of the referendum are considered by the Supreme Soviet of the Union Republic together with the Supreme Soviet of the Autonomous Republic and the corresponding Soviets of People's Deputies. Article 7. The Supreme Soviet of a Union Republic submits to the Supreme Soviet of the USSR the results of the referendum. The Supreme Soviet of a Union Republic, which includes autonomous republics, autonomous formations or places of compact residence of national groups referred to in Part 2 of Article 3 of this law, submits to the Supreme Soviet of the USSR the results of a referendum for each autonomous republic, for each autonomous formation or place of compact residence national groups with the conclusions and proposals of the relevant public authorities. If it is established that the referendum has been held in accordance with the law, the Supreme Soviet of the USSR will submit the issue for consideration by the Congress of People's Deputies of the USSR. In case of violation of the law during a referendum, the Supreme Soviet of the USSR shall appoint within 3 months a repeated referendum in the Republic either in its part, or in the autonomous entity, or in the place of compact residence of the ethnic groups mentioned in Part 2 of Article 3 of this law. Article 8. The results of the referendum on the secession of the Union Republic from the USSR and the proposals received by the interested parties from the Supreme Soviet of the USSR shall, within a month, send to the supreme bodies of state power of all Union and autonomous republics, as well as to the bodies of state power of autonomous formations to study and assess the consequences arising for each Union and an autonomous republic, an autonomous formation from the fact of a possible withdrawal of the corresponding Union Republic from the USSR. Article 9. The results of the referendum in the Union Republic on the issue of secession from the USSR, as well as the opinions of the highest bodies of state power of the autonomous regions and districts on this matter, are considered by the Congress of People's Deputies of the USSR. On the proposal of the Supreme Soviet of the USSR, agreed with the Supreme Soviet of the seceding Republic, the Congress of People's Deputies of the USSR establishes a transitional period, not exceeding 5 years, during which the issues arising in connection with the secession of the Republic from the USSR must be resolved. During the transitional period, the Constitution of the USSR and the laws of the USSR remain valid on the territory of the seceding Republic. Article 10. If, following the results of the referendum, no decision is made on the secession of the Union Republic from the USSR, a new referendum on this issue may be held no earlier than 10 years after the previous referendum. Article 11. In order to ensure the rights and interests of the USSR, seceding and other Union republics, as well as autonomous republics, autonomous formations and national groups referred to in Part 2 of Article 3 of this law, when solving issues arising in connection with the secession of the Republic from the USSR, the Supreme Soviet of the USSR, the Supreme Soviets of the Union Republics and the highest organ of state power of the seceding Republic create conciliation commissions for the transitional period. Article 12. During the transition period, the Council of Ministers of the USSR, with the participation of the government of the seceding Republic, prepares proposals on issues related to the state border of the USSR, as well as military facilities and units of the armed forces of the USSR located on the territory of the seceding Republic, and submits them for consideration by the President of the USSR and the Supreme Soviet of the USSR, which then transferred to the Congress of People's Deputies of the USSR. Article 13. The seceding Republic is obliged to observe the generally recognized principles and norms of international law, as well as human rights and freedoms enshrined in international treaties to which the USSR is a party. The question of the seceding republic's participation in the multilateral treaties concluded by the USSR, open for accession, shall be resolved in accordance with the rules established by the corresponding treaty. Multilateral and bilateral treaties concluded by the USSR and in force at the time of the exit of the Union Republic from the USSR continue to operate in relation to the seceded republic, unless otherwise agreed. The Council of Ministers of the USSR, after considering and settling all issues related to the participation of the USSR in international treaties in connection with the secession of the Union Republic from it, submits its conclusion to the President of the USSR and the Supreme Soviet of the USSR. Article 14. During the transitional period, the Council of Ministers of the USSR, government bodies of Union and autonomous republics, autonomous formations, together with the government of the seceding republic, consider and resolve issues of ownership and material financial settlements in the relationship between the seceding republic, on the one hand, and the USSR, as well as other Union republics, autonomous formations and national groups referred to in Part 2 of Article 3 of this law. On the other hand, during the transition period, the following questions: 1. The fate of all Union property objects located on the territory of the Republic, enterprises and complexes of basic industries, space research, energy, communications, sea, rail and air transport, communication lines, trunk pipelines, property of the USSR Armed Forces, defense and other facilities, has been determined, as well as property of all Union public organizations. 2. Financial and credit settlements of the seceding republic with the USSR, the relationship of banks have been settled. 3. The property and financial and credit relations of this republic with other Union republics, as well as with autonomous republics, autonomous formations have been settled. 4. The procedure for the implementation by enterprises and organizations of the seceding republic of previously assumed contractual obligations in relation to enterprises and organizations located on the territory of other Union republics, as well as autonomous republics and autonomous formations. 5. The legal status and forms of settlements of joint ventures or branches of enterprises organized on the basis of all Union property or property of other Union republics, as well as autonomous republics and autonomous formations have been determined. 6. The procedure for settlements with other states and international organizations on loans and borrowings received for the construction of facilities on the territory of the seceding republic or to meet the needs of this republic and its population, as well as on the corresponding part of loans and borrowings spent on the implementation of all Union purchases and programs used by the seceding republic. 7. The status of territories that did not belong to the seceding republic at the time of its entry into the USSR was agreed upon. 8. The status of the territories on which the national groups referred to in Part 2 of Article 3 of this law are densely populated has been agreed, taking into account the results of their expression of will at the referendum. 9. Guarantees are provided for the maintenance of historical and cultural monuments and burial sites on the territory of the seceding republic. 10. Resolved other issues requiring mutual settlement. Article 15. Citizens of the USSR residing in the territory of the seceding republic are granted the right to choose citizenship, place of residence and work. The seceding republic will compensate for all costs associated with the resettlement of citizens from the republic. Article 16. In accordance with the generally recognized principles and norms of international law and the international obligations of the USSR, the seceding republic ensures civil, political, social, economic, cultural and other rights and freedoms to citizens of the USSR, who reside on its territory, without any discrimination based on race, color, sex, language, religion, political or other beliefs, national or social origin, property status of the place and time of birth. Article 17. Citizens of the seceding republic, convicted by its courts and serving sentences on the territory of the USSR, are subject to transfer for further serving their sentences in the said republic. Citizens of the seceding republic convicted by the courts of the USSR or another Union republic and serving a sentence on the territory of the USSR are subject to transfer for further serving their sentence in this specified republic, if they committed the crimes for which they were convicted, on the territory of this republic. Issues on the transfer of citizens of the seceding republic, convicted by the courts of the USSR or another Union republic, if at least one of the crimes for which they were convicted was committed outside the territory of the seceding republic, are considered by the Supreme Court of the USSR on the proposal of the Prosecutor General of the USSR or at the request of the Supreme Court of the seceding republic. Citizens of the USSR, foreign citizens and stateless persons convicted by the courts of the USSR or any Union republic and serving a sentence on the territory of the seceding republic are subject to transfer to the USSR. Article 18. All administrative and criminal cases initiated on the facts of offenses on the territory of the seceding republic, which are in the proceedings of the organs of the USSR, are transferred through the Prosecutor's Office of the USSR or the Supreme Court of the USSR to the proceedings of the organs of the seceding republic. This rule does not apply to cases where at least one of the offenses was committed outside the territory of the seceding republic, as well as to criminal cases that fall within the jurisdiction of military tribunals. Questions about the transfer of cases are decided by the USSR Prosecutor General on the proposal of a lower prosecutor or at the request of the outgoing prosecutor, republic, and if the case is in the proceedings of a judicial body, by the Supreme Court of the USSR. During the transitional period, all civil cases are resolved in accordance with the civil and civil procedural legislation of the USSR, unless otherwise provided by an agreement between the seceding republic and the USSR. Article 19. In the last year of the transition period, on the initiative of the supreme body of state power of the seceding republic, a repeated referendum may be held once on the confirmation of the decision to secede from the USSR. A repeated referendum is mandatory if required by 1/10 of the citizens of the USSR permanently residing in the territory of the republic and entitled to vote in accordance with the legislation of the USSR. In the event that less than 2/3 of the citizens of the USSR who permanently reside in the Republic at the time the question of holding a repeated referendum was raised and have the right to vote in accordance with the legislation of the USSR voted for the confirmation of the decision to withdraw the Union Republic from the USSR, the decision to withdraw the Union Republic from the USSR is considered cancelled and the procedures provided for by this law shall be terminated. Article 20. At the end of the transitional period or in case of early settlement of the issues provided for by this law, the Supreme Soviet of the USSR shall convene the Congress of People's Deputies of the USSR to make a decision confirming the completion of the process to harmonize the interests and satisfy the claims of the seceding republic, on the one hand, and the USSR republics, as well as autonomous republics, autonomous formations and national groups referred to in Part 2 of Article 3 of this law, on the other hand. From the moment this decision was adopted by the Congress of People's Deputies of the USSR, the withdrawal of the Union Republic from the USSR is considered valid, and the People's Deputies of the USSR from the seceding republic lose their powers. The Congress of People's Deputies of the USSR makes appropriate changes to the Constitution of the USSR.